otherwise admissible shall not be judged on the case of embraces an ultimate issue to be decided by the trier of fact. Is there anything else you'd like to submit?
No.
But I'm concerned about United States versus Sheffield, United States versus Warner, United States versus Armstrong. What says the state?
Your Honor, according to 246620, credibility of a witness shall be a matter to be determined by the trier of fact. And if the case is being heard by a jury, the court shall give the proper instructions as to the credibility of the witness. Essentially, Ms. Moll was asking this witness whether Millie was credible, and that's prohibited by 246620. That's up to a jury to decide. So 246620.
All right, but more than that, I'm going to read you a couple of excerpts from the soliciting response. It says here that United States versus Sheffield in Carlson, this court is saying that fundamental premise of our criminal trial system is that the jury is the lie detector. And then there's another segment in the book which reads as follows. Accordingly, expert testimony and credibility of witnesses is disallowed by numerous rules, including 704. Because the expert opinion in this case as to the credibility, this is of the defendant in that case, is a matter within the exclusive province of the jury, and because that opinion will not assist the trier of fact by addressing matters beyond the understanding of the jurors, the defendant cannot satisfy this requirement of Rule 702. And even if the defendant could satisfy this per under 702, this is a dogma. The expert opinion offered in this case is not otherwise admissible pursuant to Rules 403, 608, and 704. There's also citation in these annotations of Carlson that states as follows: it is the jury's exclusive function to weigh evidence and determine credibility, and an expert's opinion evaluate the truthfulness of a witness's story usurps this function. Even experts cannot give this sort of opinion. Expert witnesses are generally not allowed to opine as to the credibility of other witnesses. And again, so it appears to me that, notwithstanding the fact that Rule 704 does permit, under some circumstances, opinion as to the ultimate issue, in this case, it appears to be invading the province of the jury, and so the objection is sustained. Is there anything else?
Not from the state.
All right.
No, there isn't. I think we seem to be having a problem with sleeping jurors on the top row. In the top corner.
In the top corner, his eyes are open and closed. Okay? Top left and right. But it's not like the situation we had earlier in the trial. Any other points?
Judge, I don't know who the defense plans on calling next, but if they did plan on calling Dr. Sperry next, the state does have an issue we need to take up before he testifies.
Is he after this one?
Yeah.
All right. Well, let's finish up with Dr. Powell, and then we can go from there. Perfect. Thank you. All right, let's continue.
I can answer the questions, Your Honor.
Pardon me?
No further.
No further questions. Oh, anything else?
No, Your Honor.
All right, thank you, Doctor. And your excuse.
Thank you, Your Honor.
And I didn't solicit responses from counsel, but I take it there's no objection to me being excused.
That's correct.
That's fine.
Okay, the defense will call its next witness.
Samantha Rayborn. Samantha Rayborn.
Samantha Rayborn. Please, ma'am. Swear to right hand, please.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If you could please state your name and spell it for the jury.
Samantha, Samantha, Rayborn, Rayborn.
Miss Rayborn, what do you do for a living?
I'm an attorney
Okay, and where do you work?
in New York.
And did you come down here to testify today?
Yes,
Are you going back tonight?
yes.
How do you know Jennifer Rosenbaum?
Jennifer and I went to law school together at Emory.
Did you have classes together?
Yes, we did. We had a couple of classes together.
Did Jennifer ever talk to you about wanting to become a foster parent?
She did.
Did you ever meet the girls?
I did.
And under what circumstances did you meet the Millie and Layla?
So sometimes I know that they would be at the law school, and I also worked at the snack store at the law school, which we call et al. And so sometimes they would come in there and see me there quite a bit, and they referred to it as Miss Sam's store.
Miss Sam's store. It wasn't your store, was it?
It was not my store.
About how many occasions do you think you saw the girls?
At least 3 or 4, but maybe more.
Okay. Can you tell us how did the girls react towards Jennifer?
They were happy. They would smile. They would come into the store and ask to see Miss Sam or see if Sam was working in her store. They would come in or ask for snacks. They seemed like typical kids around that age.
Okay. How did they ever act scared of Jennifer?
No.
And what did they do during class?
So sometimes they would color or eat snacks. So some of the times that I saw them, I worked at the snack store before one of the classes, and so sometimes they would come in and get snacks before the class that we had, and so they would come and get snacks to eat in the class or color and do stuff like that.
Okay. When was the last time that you saw the girls?
It was on the day of a final for our cross-examination class. It was a multi-part final. I don't recall which day of the final, but I do know that I saw them on one of the days of the final.
Okay, and was that Jennifer's birthday?
I believe so.
Would November 17th, 2015 sound right?
Right, yes.
And what did the girls do on that day?
So I was working in the snack store before the final, and the girls came in to Miss Sam's store, and I spoke to them, and they were joking around. I know one of the girls asked for a candy bar, and Jennifer said, "No candy bar, you can only have healthy snacks, girls." And we had those whole grain goldfish and stuff like that. And they got like some Cheez-Its goldfish, and we had these organic fruit snacks. And they got some snacks, and they were sitting at the table because there was some time between the time that they got there in the final. So they were sitting outside of the table, and they were coloring because they had there's a glass window inside the store so you can see outside the tables and who's sitting there at the tables outside.
Did they appear to have any marks or bruisings to you?
No.
Did they appear to be favoring an arm or a leg?
No.
Did they say anything hurt them?
No.
Did they act like anything was hurting them?
No.
Did they seem happy and healthy?
Yes.
That day, when did you find out about Layla passing?
I believe it was a couple of days later. I think I reached out to Jennifer maybe about 5 days or so after.
But you had seen the girls a day before the passage?
That's correct.
A day before Layla died?
That's correct.
You've told us about that specific day that you didn't see any bruises or marks. Did you ever see any marks or bruises on the
No.
children?
No.
Thank you, Ms. Rayborn.
Rayborn, more specifically, you work at the Manhattan DA's office, do you not?
That's correct.
And you know that the things don't always appear as they initially might, correct?
Sure.
People can put on a facade, would you agree with that?
Sure.
And I want to be very clear. What day did you see Millie and Layla? Was it the 16th or the 17th?
I believe it was on her birthday, because I know I reached out to Jennifer on her birthday, and I saw her later that day and remember thinking it sucks to have a final on your birthday. But we also had a multi-part final, so there was stuff on both days.
Okay. So are you aware that Ms. Rosenbaum actually said that the children were not with her on her birthday, the day Layla died?
Like I said, it's possible. I know I saw them because the final was a multi-part final. There was an oral part, and there was also a written part. And on the 17th, I know we also had class, and I know on that day I did reach out to Jennifer. But it is possible that it was the day before. But I do recall seeing the girls that day because I know I was working before the final because I was usually late to that class because I worked up until it.
How closely did you examine them for injuries?
I didn't. I wasn't looking particularly for that.
Okay. I want to show you State's Exhibit 12. And it's going to be behind you. Did you see that injury on her forehead?
No.
And this was the day before? This was the day before Layla died you saw her?
I believe so.
Okay. And now I'm showing you photographs of the day of Layla's death. How about State's Exhibit 19? Did you see that?
No.
Now, I'm assuming that Jennifer didn't undress them in the middle of class, correct?
Not that I saw.
All right. So, do you recall the parts of the body that you actually saw?
Probably the arms, and it was in the fall, so they probably were wearing just a short sleeve without their jackets indoors.
Okay.
And obviously their faces.
I'm going to show you State's Exhibit 45. Did you see that?
No.
Let's show you State's 48. Did you see that?
No.
As a prosecutor, would that have concerned you?
Under what context?
Under what context? That wouldn't have concerned you, just seeing those.
It depends on the context, the facts of the case.
What do you know about the facts of the case?
Other than, what do you mean? Like, what do you know?
Yeah, what do you know about the facts of the case?
That I know that Jennifer is charged and we're here for her trial.
Okay, but what do you know about the underlying facts?
Other than the day Layla passed. I mean, I wasn't there, so I don't know.
Okay. Did you hear anything about choking?
Sure, on the news.
Okay. Would you expect someone to perform the Heimlich maneuver in the vaginal area?
On a child, on an infant, the way you hold an infant, well, I'm not an expert in the Heimlich maneuver on infants, but I don't know it's the same way. I think you bend the child over your arm, so I don't specifically know your arm's supposed to go up and through the legs, but once again, I'm not certified in the Heimlich maneuver, so I don't know.
So you think you would see State's Exhibit 53 from the Heimlich maneuver?
I can't tell you the answer to that.
You're friends with Jennifer, are you not?
I am.
Did you see State's Exhibit? Did you see the injuries that you see on State's Exhibit 67?
On
Layla, the day that you saw her?
No.
Okay. Did you see that part of her body?
No.
And would that have concerned you?
If I saw it that day, yes.
Would you agree with me that the sections of the body that we've seen here in court today are sections that would have been covered by clothing?
More likely than not, yes.
Nothing further.
Any redirect?
Before passing judgment, would you want to know the context?
Right, which is why I said I'm not certain to some of the questions, because every case is different and you would need to know the facts before you could make some sort of conclusion.
As a prosecutor, are you taught to look at the facts first?
Correct, so part of my job is to investigate. Even if someone has been charged or there's pending charges, we would investigate.
Thank you, Mr.
As a prosecutor, if someone gave conflicting histories, would that concern you?
It depends on what those conflicting histories are.
Okay. Well, talk about it then. Were you aware that Layla broke her leg?
Yes.
You were. Were you aware that she told different people different things?
No.
Were you aware that she went to the doctor, the first doctor, and told the doctor that she fell at the Nana's house and also fell at gymnastics? Were you aware of that?
No.
Were you aware that she went to an orthopedic doctor the next day who had concerns about child abuse, who sent her to Children's Healthcare of Atlanta at Eggleston?
No.
Were you aware that Ms. Rosenbaum did not go despite saying that she would?
No.
As a prosecutor, would that concern you?
Possibly.
Possibly. How about she goes to another doctor 3 days later, and it doesn't give the same history? She leaves out the Nana part. Would that concern you?
Possibly, yes.
Would it concern you that the biological family, she never mentions anything about falling at Nana's house? Would that concern you?
To the biological family?
Correct.
I'm sorry, could you repeat the question?
Would it concern you that she never mentioned the fact that the child fell at Nana's house? Would that concern you that she never told Nana or any of the other biological family that?
Well, I guess I'm misunderstanding your question, in that she never told them or that she told them something different?
She only told them that the child fell at gymnastics. She never told them that the child also fell in their backyard. Would that concern you?
Possibly, yes.
Would it concern you to find out that she hadn't been to Nana's house in months?
I would object to statements of alleged fact that hasn't been proven, because that's why we're here, is to prove facts.
Simply asking.
Jury is the finder of fact. I'll allow the question.
You can answer.
Could you repeat the question?
Sure. Would it concern you to find out that she hadn't been to Nana's house in months?
Yes.
That would concern you?
Yes.
Okay.
If I had the opportunity to, if I were the one investigating and that turned out to be true. Yes.
So conflicting stories from a defendant are concerning as a prosecutor. Is that not true?
Depending on the varying statements, that could be possible. Yes.
Okay. And if she gave varying statements regarding the child care, specifically whether or not the child was in daycare, would that be concerning to you as a prosecutor?
Possibly. Depends on the circumstances.
Sure. How about she told the DFACS worker that was supervising the case? The DFACS worker, she told that the child was in daycare, and it turns out the child wasn't. Would that concern you as a prosecutor?
Possibly, yes.
Possibly. Under what circumstance wouldn't that concern you?
Like I said, I don't know all of the things, so these questions are kind of isolated, and I'm not the prosecutor in this case. So I think there would have to be more facts for me to come to a conclusion.
Okay. But would it concern you?
Possibly, like I said, without knowing all the facts or all the things that exist out there, I can't really say for certain yes or no, because I'm not the prosecutor in this case.
Okay, nothing further.
All right, thank you, Ed. You can sit down. Any objections to this being excused?
No objection, Your Honor.
No objection.
Okay, you're excused. The defense will call its next witness.
Sana Rupani.
Please raise your right hand and spell this for everyone.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Rupani, would you state your name and then spell it, please?
Sana Rupani, S-A-N-A. My last name is R-U-P-A-N-I.
And Ms. Rupani, what do you do for a living?
I am a family law attorney and a guardian ad litem at Marple Rubin Family Law.
Is that in Georgia?
It is in Atlanta.
In Atlanta. Do you know Jennifer and Joseph Rosenbaum?
I do.
And how long have you known them?
I met Jennifer the spring, so January of 2013.
And where and when did you meet?
We were both working as interns in the governor's floor leader's office at the Georgia's legislature.
And did you ever have an opportunity to meet Layla or Millie?
I did meet both of them when Jennifer would bring them to law school with her.
And when she brought them to law school, under what circumstances, where were they? They with her or they sit outside? What was the situation?
They would generally be with her, Jennifer and I, that semester, the last semester of the first semester of my third year of law school. We had classes together, and so she would bring them with her, and they would either come to class with her or they'd be hanging out, around us.
Okay. And turning your attention to the fall of 2015, do you remember Millie coming to Emory?
Yes.
Do you remember what Jennifer's reaction was like that day?
The day, I remember more than one day that...
In the fall.
Right.
Did there come a time where Jennifer came to the law school and she was crying?
Yes.
Can you tell us about that?
I specifically remember in November, Jennifer and I were actually trial partners. We were in a class where our final was a trial to be put on. It was a DUI trials class, and we were going to meet to prepare for the trial because we had to do a full openings, closings, direct, as if it was a real trial. And she wasn't able to make it. At that time, she didn't tell me why. And then when we did eventually meet, we met at the library at the school, and she told me that...
Objection. Here's the...
Don't tell us what she told you, just what was her reaction?
She was very distraught and upset that day.
Okay. Did you have occasion to ever take Millie to the bathroom?
I did.
And can you tell us about when that was?
It would have been earlier in this semester. She was still wearing clothes that it would have been warm outside, so probably September or October.
Okay. And did you have to undress her?
I had to help her get dressed again, so I took her to the bathroom, and I think she was in like a leotard or a ballet costume, and so it was a little bit snug on her, and so she was able to go to the bathroom by herself, but then when she was done using the restroom, I had to help pull the leotard over her because she was so small.
Did you see any bruises, cuts, or lesions of any sort on the body of Millie?
No, not at all.
Looking at October and November of 2015, were there any other issues with Jennifer and that she came in upset?
No, not that I remember.
Okay. Did she ever confide in you about the children's great-grandmother?
Oh, yes. I think she was more concerned than upset when she was talking to me about that. She was concerned about the girls and when they would visit with grandmother and then when they would come back. And
why is that?
The girls were more agitated, or they seemed different.
Judge, I think her response actually calls for hearsay.
It does.
I'll move on. Do you recall the time when Layla passed away?
Yes.
And did you have an opportunity to see Jennifer shortly thereafter?
Yes, I did.
And what was her demeanor?
She was very upset. We actually cried together.
And normally, what is her demeanor?
I had never seen her so broken.
But normally, what is her demeanor?
She's very well put together, can carry the weight of the world on her shoulders, but this had broken her.
Thank you. I have nothing further.
All right. Cross.
You can't tell us what was in her mind, though, can you?
Sorry?
You can't tell us what was in her mind, though, can you?
No.
You can't tell us what she might have been thinking about when she was crying, can you?
No, I don't know the thoughts that were in her brain when she was crying, no.
Regarding Millie, you saw her, you said earlier that fall.
Right?
Had you ever been to the Rosenbaum's home?
No.
Okay, so you don't know what happened in the home, correct?
No, I don't know what happened in the home.
And you only saw the girls, was it once or twice?
It was a few times over the course of the semester.
And it was at school, correct?
Right.
As far as Layla is concerned, did you ever see Layla without her clothes on?
No, I didn't see either of them without their clothes on.
Okay, just Millie, one time you took her to the bathroom?
Yeah, I helped her get dressed again.
Okay. But that was much earlier in the semester and not close to November 17th of 2015, correct?
It would have been September or October.
Nothing further.
All right, thank you, ma'am. You can step down and you're excused unless there's no objection.
No objection.
Okay. Free to go.
Kelly Suttles, please.
Kelly.
Suttles. Your Honor, at this time, I would call Dr. Sperry to the stand.
We have
something to take up.
We do have an issue to take up.
All right, we have an issue to take up. Outside of your presence, ladies and gentlemen, could you please step into the jury? Thank you.
May I check and see about Ms. Suttles, because I really did want to call her before Dr. Sperry. If I could just make sure that somebody's trying to get her while we're talking.
You can go ahead and take a moment.
Thank you.
Okay. Are we, Ms. Moore,
Yes.
is your witness present?
She is 5 minutes away, Your Honor, so I think during the time we're talking, she'll be here by the time we get through.
So we can deal with this issue and then perhaps call that witness
That's right.
and follow up with the doctor. Okay.
Judge, I wanted to bring to the court's attention a discovery violation. And the state is seeking to exclude this particular evidence. This morning, Ms. Mull handed me what are 4 microscopic slides that apparently Dr. Sperry has done in this particular case. The reason, this was obviously something that was, well, let me back up. The way that the GBI works is that they don't hand out the original slide that the medical examiner does, but if the defense requests it, they actually send it out for another cutting, and that cutting is done, microscopically very close to the original slide, and then they can get those particular slides. Ms. Mull hands these 4 slides to me this morning, indicating that Dr. Sperry intends to testify about these 4 slides. However, in speaking with GBI, the slides were received by the GBI on October 10th of 2017, and they had a conversation with Ms. Mull on October 12th of 2017, and she advised that she would be coming to pick the slides up that particular day. So the slides have been in the defense's possession for almost 2 years now, and we are just now getting these particular slides. The fact that they've had them in their possession for so long, I think, goes to satisfy the bad faith prong. That this is something that they knew about, and that they're attempting to spring upon us at the last minute. As far as the prejudice, Dr. Darrisaw has already testified. Dr. Darrisaw, we were not given this prior to her testimony so that we could ask Dr. Darrisaw her opinion on these particular slides and whether or not these slides differed from the other slides. Dr. Darrisaw, unfortunately, is now out of town. She's traveling to a family reunion and is not available to come back. That's clearly prejudice. And the defense knew that this was something that they were going to go into.
Was Dr. Darrisaw excused by the court?
I believe she was.
And there was no objection?
There was no objection.
By either party?
Because at the time I had no idea. Had we known about this, we may have asked her to stick around. But they sprung this upon us at the last minute. And I think that clearly goes to bad faith and prejudice. As to whether or not this is, and I'm anticipating the defense is going to say it's in reaction to something that Dr. Darrisaw said on the stand. However, I know for a fact, because I spoke to Dr. Sperry on the phone, Ms. Mull was on the phone as well, and I know for a fact that the reason, or that this is something that they anticipated as something that they were going to go into during the course of their defense, that they were going to talk about what Dr. Sperry will say is a non-union fracture. When we spoke on the phone, they were talking about Dr. Darrisaw's, he talked about looking at Dr. Darrisaw's slides, and at no point did he mention that he had his own. In fact, I asked Dr. Sperry last night, or when he's just in the hall right now, when did you make these? And he didn't even make them until last night. But the defense has had them for years. So to just now spring this on us and not give us the opportunity.
When you say that he made them last night,
so he took...
I'm a little confused by that because I'm hearing that there was a request made to the GBI for the slides way back, and that the defense has had them for 2 years.
The slides
and now you're telling me something about last night. I'm not sure what difference is there.
Sure. So they've had the slides for 2 years. He took the photograph that was provided to us last night using a microscope camera type thing. But they've actually had these slides in their possession for years. So this is something that they could have had him do well beforehand.
But you're talking about photographs of the slide.
And this is not a slide this is a slide that was cut by the GBI but handed to the defense. So theoretically, we could have had Dr. Darrisaw bring in her slides, but this was not something that was ever provided to us to give us an opportunity to have Dr. Darrisaw, number one, perhaps bring her slides, but number two, compare and contrast the slides that we see here. Frankly, I don't know what I'm looking at. I don't think any of the lawyers in here know what we're looking at. And then to allow the defense to kind of spring it on us at the last minute, and without really a chance to allow the person who did the examination and actually took the punch biopsies to come in and testify about that, I think would be unfair, and it's clearly a prejudice to the state.
So all you're seeking to do is to exclude actual photographs.
Sure.
So for instance, if there's testimony about whatever might be contained in the slide, that's the core of some expert opinion. You don't have an issue with that. You have a problem with the actual admission of these slides because they weren't furnished until now.
Correct. I mean, because I will say that Dr. Sperry told me that he looked at he told me he looked at the slides. He didn't take the photographs. But yes, he told me he looked at the slides. Okay. But I think that the admission of the slides themselves it's what's prejudicial to the state.
Your Honor, first of all, these slides are existent and in the possession of the state. We had to make a special request through the court to get a hold of the slides, to get a copy of the slides. We got a copy of the slides. We did not anticipate using the slides or using pictures of the slides until Dr. Darrisaw and another medical witness testified and talked about non-union joints and talked about what the tibia looked like and what the ulna looked like. This was as a result of state witnesses' testimony and my discussion of state witnesses' testimony with Dr. Sperry and him saying he has proof that that is not the case. What the medical witnesses were saying was not the case, and he had that in the slides, and so he said he would take a picture of them. The minute I got the picture, I gave it to them, and we certainly can recess tonight and they can have an opportunity to spend more time with the photographs, but there's been no violation because as the state has said in the past and has put in all of its documents, that anything that is in discovery is fair game. Any witnesses that are contained in the discovery are fair game. Any documents or slides that are in the discovery are fair game. And the slides were in the state's possession, in Dr. Darasaw's possession, and we had to get a copy of them. We didn't get the real thing, we got a copy.
Are these, what I'm hearing is the state saying that these are different slides than the ones that they had.
That would be.
That they are, that's what I'm hearing.
That would.
Is that correct?
Yes, I spoke to Dr. Eisenstadt, who is now the chief medical examiner at the GBI, and he's the one who explained it to me. They take when the defense requests it, they get a different cutting. They basically take it and make another cutting. The other issue is that as far as the quality of the camera, the quality of the microscope, all of those things could factor into what we are looking at. And that's something that Dr. Darasaw might have been able to do had the defense provided this to us in advance.
So they requested a separate cut.
Yes, and that's standard procedure.
And they received it.
They received it October 12th of 2017.
And they did not provide you with any notice that they intended to use that separate cutting at trial.
Correct.
We did tell Mr. Boring at the time that we wanted the slides to be used for trial. And we had him to tell us the procedure to obtain them. He was representing the state at the time and explained to us exactly how we were supposed to obtain them.
Getting the cutting is one thing.
Yes.
And then making a determination you intend to use it at trial is another. And then producing them is what's required in the reciprocal discovery statutes. If in fact you are intending using the trial, you have to do that in a timely manner. This doesn't seem to be timely to me.
Your Honor, I did it I served it as soon as I knew we were going to use it, and the only time we knew we were going to use it was after Dr. Darasaw testified. And so it would be in the kin of rebuttal evidence, and I gave notice as soon as I got it.
And Judge, if I can just provide some more clarification, when Ms. Small handed them to me, I asked her what they were, and she said pretty. And then she said, I asked specifically what it was, and she was hesitant to tell me what fractures these actually were from.
I said they were ulna and tibia, and I gave him, he wanted a copy, and I let him have a copy.
Well, I'm going to go back to one other issue before I kind of make a ruling in this, on this issue, and that is, so she requested the cut back on October the 10th.
The cuttings, no, she requested the cuttings prior to that. The cuttings get sent to an outside lab.
Okay, so the request for the cut was when?
The request for the cutting, they didn't provide me the specific date for the request of the cutting.
I know.
They provided, but it would have been obviously before October 10th.
Okay, so October the 10th, tell me what happened that day.
The GBI received the cuttings in their possession, and then they...
The defense's cut?
Correct.
Okay.
And then on October 12th of 2017,
October 12th.
Ms. Mull called to say that she would be picking up the slides that day.
All right. And then, how do I test the assertion that the defense didn't know until after the doctor testified that the slides, that the pictures of the slides would be necessary?
We would need to put Dr. Sperry on the stand, and we would need to ask him when he talked to me about the slides and when he produced the slides.
I think we might need to have some proffer around this to determine whether or not there's been a discovery violation.
And Judge, we can certainly do that. There's no dispute as to when he created the slide. I have no doubt that Dr. Sperry actually took the photograph that I see here today last night.
His opinion hasn't changed about the necessity of using this slide based upon the evidence that has been presented by the state, and that's the input.
Well, perhaps, but the Dr. Derisaw, as the court can recall, we did not put any slides on the stand. She said that, you know, she saw microscopically. I discussed that with Dr. Sperry on the phone, with Ms. Mull on the phone as well. That microscopically, he saw these features that he thought led him to believe that it was going to be a non-union fracture. These are all things.
When was that?
That was. It was after trial began, but that would have been July 14th.
July the 14th?
Yes.
And his opinion at that time was what?
That when he looked at the slides, or when he looked at the slides,
Excuse me.
he saw microscopic, I guess features is the word I'll use, that led him to believe that this was a fracture that was not healing properly. It was a non-union fracture.
A non-union fracture. He saw microscopic features, non-union fracture. And that was his opinion on July the 14th.
That's correct.
Okay. And so at that point, he would have been making a showing or testifying to that using whatever exhibits that he had to reflect that. Is that true or not?
Yes, and I mean, like I've said, I don't have any issue with him saying what he saw. The problem is we just don't, because he talked to me about that. But then to show the photographs without us being able to really test whether that's the.
So these photos are consistent with his opinion of July the 14th.
And I don't know that.
That's my question.
Right. And
So-
that's the prejudice that the state has, because I don't know that.
It's not necessarily a prejudice to the state. It could be. It really depends in part upon what the doctor says about whether or not his opinion has changed since July the 14th. And why. And it's a discovery violation issue. I need to know if in fact, if his opinion has not changed since July the 14th, and you're producing these pictures now, then I have a little question about why they weren't produced previously. If his opinion has changed somehow since July the 14th because of some testimony that has occurred, and when did the medical examiner testify? It was Monday of this week.
It was Monday this week, yes.
And Monday of this week, what was the date? Pardon?
I believe it's July 22nd.
July the 22nd. And it was in the, was it in the morning or the afternoon? They're both.
Both.
So it seems to me that if his opinion had changed, then it would have been, and he intended to use this as evidence to support his changed opinion, then you would have had to produce it immediately thereafter, or as soon thereafter as possible. Would you agree?
I would agree, except that we didn't discuss it because we had other witnesses that we put up and we were dealing with. We did not discuss it until night before last.
So, but, okay, so the night before last is, today's the 24th. So on the 23rd, you discussed it.
And then last night, he told me he had the pictures of the slides.
So tell me what these are slides of again. You say the old?
Of the ulna, some of them of the ulna and one of the tibia.
And tibia. And specifically, just continue with that. From whom and taken when? Just give me some details, right?
These are from the cuttings that were provided to us by the GBI, and these are what Dr. Sperry took pictures of last night and sent to me last night, and I delivered this morning to the state.
I'd like to hear from Dr. Sperry about whether or not his opinion has somehow changed since this testimony was given on July the 22nd.
I actually have an extra copy of them in color if the court wants to see a copy.
Not so sure about that, but it's going to help me at all.
Hey, you know, I might
Thank you.
find it interesting.
With my zero medical training. So the question then is still one of, it's still an open question. Let's hear from him about what he knew when he knew it.
Beginning.
Come on up. Raise your right hand, please. You solemnly swear affirm the testimony about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
State your true and correct name.
Sure. My name is Kris Lee Sperry. My first name is spelled K-R-I-S,
And your last name is spelled?
S-P-E-R-R-Y.
I don't know that we need to spend a lot of time on credentials at this point. It's not relevant as our inquiry.
You want me to start?
Yes.
Dr. Sperry, when did you decide to provide that you were going to use these pictures of slides in your testimony? When did you make that decision?
Yesterday morning.
And what caused you to make that decision? Had anything changed since the first time you had looked at had there been anything intervening that caused you yesterday, as opposed to any other day, to make these pictures?
Well, I thought it was necessary, or it would be useful, I think, to show the difference between the state of healing of the fracture in the right tibia bone, and also in the left ulna, and that these were markedly different, and in their microscopic changes of healing, which is not something that can be appreciated at all on the x-ray.
And was this as a result of hearing about Dr. Darasaw's testimony on the stand?
Yes.
And was this as a result of hearing about the Dr. Darasaw's position on non-union joints and the rate of healing in the ulna and the tibia?
Yes, basically that my understanding that it was stated that non-union fractures are very, very rare in children, which I agree, but it doesn't mean that they're impossible. And again, the microscopic features to me were so dramatic that I thought this would really provide visual understanding, excuse me, for the opinions that I was going to offer.
And was this as a direct result of what Dr. Darasaw, what was reported to you that Dr. Darasaw said?
Yes.
Did you feel that Dr. Darasaw's position was different than what you thought it had been?
Yes.
Thank you, that's all I have at this time.
All right. Dr. Sperry, I want to talk about your opinion, though.
Sure.
You remember talking to me on the 14th, correct?
Yes.
We had a nice telephone conversation for about 45 minutes, right?
Yes, you were very nice at the time.
Am I not still?
So far.
So far?
So,
You anticipating that change?
one never knows. We're
Right.
just starting.
Has your opinion changed, though, regarding the non-union fracture? Did anything change about your opinion between when we talked on November 14th and as we sit here today?
No, I think actually you and I spoke about that. I told you, what my opinion was regarding the ulna fracture as compared with the tibia, and after we had a brief discussion, and that was about it.
Okay. And that was from looking at the slides that were provided to you by the defense, correct?
Correct.
All right. So nothing, since July 14th, nothing has changed, nothing that you heard about Dr. Darasaw's testimony, that didn't actually change your opinion in this case, correct?
Oh, no, not my opinions, no.
Okay. And were you told about Dr. Darasaw's testimony, or did you watch it?
Oh, I've not watched anything at all. I mean,
Okay.
I understand that I was at least witnesses were instructed not to, but I don't anyway. I don't watch these things on TV
All right, I don't blame you.
at all. Even whatever things that I've been involved in myself over the decades, I don't watch on TV.
All right.
So,
Thank you, sir. That's all for now.
thank you.
What was it about Dr. Darasaw's, what was reported to you about what Dr. Darasaw said that made you feel like you needed to take these pictures?
Well, the non-union fractures were very, very rare in children, which, as I said, I agree, they are very rare, or maybe the terminology of something like almost unknown, but they exist, and actually there's a small body of literature addressing these, that they do exist. And the vast majority of time, non-union fractures, or I would say fractures that really exhibit very poor healing, are a clinical diagnosis where, say, a child, since we're talking about children, sustains a fracture of some bone, and then time goes by and it doesn't heal properly, but it's seen and understood and watched over the course of months by whatever orthopedic physicians are caring for the child. And so the fact that the fracture is not healing properly is recognized along the way. In this particular instance, where the first time that I know of that this fracture in the ulna was identified was really at the autopsy examination, is very unique. And there were sort of x-rays that were taken of the child as part of the skeletal survey where this was found, and then the sections of the bone were taken at the autopsy for examination. And and appropriately, this is a good thing, because all of these injuries, everything should be looked at microscopically if at all possible. And I mean, lo and behold, at least when I looked at the slides, there was a very marked, very radical difference, certainly between the tibia and the ulna. But the ulna alone, that fracture clearly shows significant evidence that it has been there a long time. I don't know how long, but it could be many months, and has just not healed.
Did Dr. Darasaw, was it reported to you that Dr. Darasaw said anything about the healing time, that she placed the injuries as occurring on a certain date?
As I recall, I think it was 3 to 4 weeks was the time frame that I was told.
And you disagree with that?
Certainly with the ulna fracture, yes.
And you wanted to show that?
Yes.
Thank you.
Very quickly, nothing about your opinion, though, from July 14th changed based upon anything Dr. Darasaw said, correct?
No, nothing about my opinion changed. I think, I told you what my opinion was, and I didn't think at that time that I would be taking photomicrographs, but at least from my own perspective, sometimes I have found it's easier, for everyone in the courtroom who's not a doctor to look at something and have me tell them what it is, and then they can make up their own mind.
Thank you, sir.
Thank you.
Okay, thank you, doctor. You can step down. We'll come back to you soon.
Thank you, sir.
All right. I'm going to exclude the votes. We have another witness.
Yes, Ms. Suttles.
Okay, let's call Ms. Suttles. Right up here, please, ma'am. And once you get the witness in, we'll bring the jurors up. bring out the jury. Sorry for the delay. Are we working? Ms. Ball.
Ms. Suttles, would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Ms. Suttles, what do you do for a living?
I'm an accountant. I'm a CPA.
CPA, and where are you a CPA?
Please, have you had her spell her name?
No, I haven't. You're right, Judge. Could you please state your name for the court and spell it?
It's Kelly Suttles, Kelly Suttles.
Can everybody hear her? No. We're just going to just speak up a little bit or soft speak.
Sure.
Where are you a CPA?
I work for a private company called CP Kelco.
And how do you know the Rosenbaums?
I go to church with them.
Okay. And tell me about church with them. How often do you see them at church?
They have been, or Jennifer has been, in my small group several times, and that's most of my contact. It's a large church, so there's a lot of people I don't see every Sunday. But she's been in a few of my small groups over the years.
And specifically in 2015, tell us first, what are the small groups? What does that mean?
So they meet on a regular basis outside of Sundays, so they can be any day on the week. Ours met on 2 Saturday nights a month during multiple semesters. And does that adequately answer the question? Okay.
And so how often, you say 2 Saturdays in a month,
Mm-hmm.
so twice a month you met?
Correct, yes.
And are children invited as well?
Oh, yes. Ours was actually a game night small group, and so it was all families. So there were lots of children there and lots of people.
And game night meant what?
So we would get together and share a Bible verse and pray together before we got started, and then we'd have all kinds of food, and we'd have all kinds of games going on in different pockets of the house, different games.
And where are the children at this point?
Some of them would be upstairs playing video games. Some of them would be playing the games that the adults were playing. They would be all over. Some would be playing outside. They'd be all over the place.
Did Jennifer bring Millie and Layla to the small groups?
Yes.
And was there anything about the girls that alarmed you?
No.
How late, what's the latest that you remember seeing them at your small groups?
Oh, I'd say they go till 8 or 9 o'clock.
I mean, in terms of from this November or December or October, September of 2015, when in 2015?
September. I think that they were there in September 2015.
Were they there in October?
No, ma'am.
And were they there in November?
No, ma'am.
Any signs of bruises or cuts on these children?
No, ma'am.
And when you went to church, there's a daycare at church, and the children are. What is the system for the children to be dropped off at church? Daycare.
Generally speaking, they're dropped off at a check-in counter or at the individual room, and they get a sticker that matches the number on it, matches what the parent gets, so that the parent can pick them up. I think that's
it. Okay. And did you have occasion to see Millie and Layla be dropped off at the church daycare?
No, ma'am.
You've never seen them there?
No, it's a very separate area from where the rest of the church is, and so I wouldn't have been around that. I don't have children of my own.
You don't?
yet.
And at your church small groups, were there other children there?
Yes, ma'am.
And so the children would play together?
Yes, ma'am.
Does it get rough and tumble at times?
Sure, absolutely.
Rambunctious?
Mm-hmm.
Thank you, Ms. Suttles.
Good afternoon, Ms. Suttles. When we would get rough and tumble and rambunctious, would any of those kids end up with broken arms, broken legs, or broken ribs?
No, ma'am.
And what church is it that you attend?
Turning Point Church.
Turning Point, and you talked about daycare. Is it like Sunday school or Sunday church for kids?
Yes.
And that's on Sundays, not on Wednesdays, correct?
Yes, ma'am. They have it on Wednesdays when we meet on Wednesdays, yeah.
Who meets on Wednesdays?
We have a first Wednesday service.
Okay, first Wednesday?
Yes.
Of the month? Mm-hmm. Okay. What about the second Wednesday of the month?
No, ma'am.
Okay. And you said, but you never saw the kids being dropped off to the daycare?
That's correct.
And the last time you saw the children would have been in September of 2015.
Correct.
Was that at the church or was it at your home or someone
at
else's
my
home?
house.
At your house. And you didn't observe any injuries or bruises to the children at that time?
No, ma'am.
Were the girls able to run around and pick up things?
Yes.
No one had any issues with their arms or legs at any time while you were there?
No, ma'am.
And after September of 2015, did you ever see the girls again?
No, ma'am.
Nothing further.
Do some small groups meet at the church?
Yes, on occasion.
And do they provide daycare at that time if they meet at the church?
Usually, yes.
And how big a church are we talking about?
About 2,000 members.
So you wouldn't know where other members, what small groups they belong to?
Correct.
Okay, and you can belong to more than one small group?
Absolutely.
Okay, thank you so much, Ms. Ellis.
Okay.
How long have you been a member of the church?
14 years.
14 years.
Yes,
And
ma'am.
to your knowledge, it's only on Wednesdays, the first Wednesdays of the month, that they have meetings.
Yeah, the youth meet on the other Wednesdays of the month, but broad spectrum church meetings are only first Wednesdays.
And the youth, we're talking about the teenagers.
Correct. Middle
Not
and high school.
4-year-old, so I didn't mean to interrupt you.
It's okay. Middle and high school,
So not 4-year-olds and 2-year-olds.
unless they belong to volunteers for the youth. Then I believe there's childcare for those.
And to your knowledge, the Rosenbaums weren't volunteers for that youth group that met on those Wednesdays.
Not that I know of, but I wouldn't know that.
And those meetings with those teenagers were in the evening at 6 or 7 p.m.?
Correct.
Not at 2 o'clock or 3 o'clock in the afternoon?
Correct.
Oh, nothing further.
But the small groups do happen at different times of day and different days of the week. And again, that's not something I would be aware of.
Nothing further.
And some of the small groups would occur at church during the day, correct?
Yes.
Thank you.
Anything else, Ms. Young?
Nothing further.
Oh, thank you. You can step down.
Thank you.
And any objections, witness being excused. Ms. Young?
No.
Oh, you're excused. Okay. Does it make sense for us to break now? I take it that Dr. Sperry will take some time. Okay, ladies and gentlemen, we're going to break for the night, and we'll see you back here tomorrow morning, 9 o'clock. Thank you again for your time and attention today.